Sorry for the delay. Waterlogging. And second half, this court will not sit. There's some death in the family. We have to rise early. Yes.
May I please, your lordship? But I am paying for listing a matter tomorrow, my lord.
Motion.
Lordship.
May I please, madam? I beg to mention item number 18 and 19. Madam.
18 and 19, yes.
The both the matter become under infraction.
PWD.
I have
And
informed my.
As anybody is there in the from PWD?
BTC standing consider.
Okay, anyone from PWD? Who's there?
Informed
Okay.
Nayak.
Who's there normally? B Gogoi.
No, P Nayak.
Pinayak is there. Is he there in the court today?
Yes.
Okay.
I informed.
Sri M. Kolita, learned counsel for the petitioner, has submitted that by flux of time, the matter has become infructuous. Full stop. Also heard Sri P. Nayak, learned AAG, appearing for the state departments, and Ms. B. Bora, learned standing counsel BTC, who do not do BTC full stop. In view of the aforesaid submission, petition is dismissed as infructuous. Same order in 19. Separate, huh? Petitioner, AK. Yes.
May I please, Your Lordship, for listing of a motion item.
May I,
When tomorrow?
may I, Your Lordship, I beg to mention item number 14 and 15, Lordship.
14 and 15, yes.
I have taken consent from Mr. B. Gauhati, Lordship. This matter may be fixed on 11th, Lordship.
11th. On a request made by Sri AMS Mazumdar, learned counsel for the petitioner.
Yes,
Matter is adjourned to be listed on 11/8.
Lordship.
Next Tuesday.
Yes.
Okay.
Problem.
Yes, madam.
Your Lordship, I beg to mention item 10.
10. Yes.
Some time to file the affidavit.
File.
The affidavit.
In this case,
You're for APDCL. Yes, Mr. Sharma. Yes, what do
The
you?
interim order may continue.
Okay. How much time, madam?
Your Lordship, we sent it for vetting. So
Sent for 2 weeks will be enough. Okay. The learned counsel representing the APDCL has submitted that the affidavit has been prepared and sent for vetting, and accordingly she prays for some time. Para. Also heard Sri A. Sharma, learned counsel for the petitioner, who has informed that there is an interim order operating. Para. In view of the above, matter is adjourned by 2 weeks to enable filing of affidavit in opposition. Para. Interim order passed earlier stands extended till the next date fixed. Full stop. List on 19th of August. 19/8.
May it please your lordship, I beg to mention item number 11.
Yes.
Due to the personal difficulty of the main counsel, he will not be able to be present before this honorable court. May it be granted after 3 weeks, your lordship.
3 weeks. Why 3 weeks? Pleadings are over.
It is in admission stage, your lordship.
Pleadings have been completed or not? Forest? You have filed your affidavit.
The thing is that there is speaking order, speaking explains everything, why you have.
So why do you need 3 weeks? 1 week?
Your lordship, I need to receive instruction from the senior regarding the same.
No. You accommodate your senior, but not 3 weeks. Well, 1 week. Okay. Who you are making a mention of whom? On behalf.
G.R. Datta, your lordship.
Okay. On a request made on behalf of Sri G.R. Datta, learned counsel for the petitioner, matter is adjourned to be listed on 14th of August. Sri
Your
R.R.
lordship, any other date except for
17th of August. 17th of August. Sri R.R. Google, learned standing
Much
counsel
obliged.
first is present.
May I please your lordship? Lordship, I beg to mention item number 9 to kindly
Nine.
pass over for the day, lordship.
9.
Yes, lordship.
On behalf of?
On behalf of M. Biswas.
Okay. On a request made on behalf of Sri M. Biswas, learned counsel for the petitioner, matter is adjourned to be listed on Friday. On 12th, what would be the date? 7th. Okay?
Next week.
Next week, then 10th. 10th August. Sri R.R. Google, learned standing counsel PHE is present.
Deeply obliged, lordship.
Item 30. The Jekazuli matters.
That's occasionally matter.
Where are the council?
Lordship. Even, even tomorrow list, there are certain matters listed.
Tomorrow.
Even tomorrow also. So may I pray, let the matter be, all this matter be taken up on Monday, we'll file an affidavit, Lordship.
Then it has to come tomorrow to get an order in those cases because those matters will come tomorrow.
Yes, Your Lordship.
None appears for the petitioner on call, whereas Sri R. Gogoi, learned standing counsel Forest Department is present. Para, Sri Gogoi, the learned standing counsel is informed that similar matters are fixed tomorrow. Para, in the interest of justice, these matters are adjourned to be listed again tomorrow. This will be 30.
21, 22.
30 and 21.
They are connected items, Your Lordship.
Yes, 30 and 21.
Yes. 21, 22, 23, 24, everything.
Okay, okay.
Same order, let it come tomorrow. Okay.
But they should have been here.
Yes, Your Lordship.
Where is Mr. Chaudhary, HRA Chaudhary and Mr. Ahmed? Okay, nonetheless.
May it please the Lordship. If I have verified the record on the other day, my learned friend is intimating this matter may be taken up, sent for appeal. But the thing is that Lordship, I have challenged annexer J and K these two letters, Lordship, and to my information, it is not the appealable order, Lordship. It is in a final order and.
Now, in that case, we can hear this
Yes, Lordship.
23 matter.
They have not filed their affidavit.
Additional affidavit.
Have you filed?
No, we are about to take instruction in this matter, Your Lordship. Additional affidavit they filed on 27/26.
And they have not filed their affidavit also for a long time, Lordship. They have been taking up times and times, every occasion.
When did you file the additional affidavit?
We received on 27/26,
7 July.
7 July.
Okay, okay, sometime we'll grant, okay?
Lordship, as a last time, because there is several last time has been
Okay,
given.
okay. Heard Sri R. Sharma, learned counsel for the petitioner, who has submitted that the orders under challenge are not appealable in nature. Full stop. On the other hand, Sri R. Gogoi, learned standing counsel Forest Department, has submitted that apart from the preliminary objection regarding availability of an appellate forum, the petitioner has filed an additional affidavit recently on which he is required to obtain instructions, full stop para. In view of the aforesaid submission, matter is adjourned to be listed on, today is 4th. We'll have it on 24th. Okay, 24th, but for, no, not 24th, 25th, but for disposal.
Yes. Well, in
Yes,
the meantime,
24th? For admission hearing.
Yes, sir.
Obligation.
It's a 23 matter.
May it please your lordship.
Yes.
In support of my case, my lord, I am relying a judgment, my lord, that is disposed on 2/6/2026. Petitioner, my lord, petitioner husband had a fair price shop, my lord, and he was expired on, my lord, 14/9/2020, my lord. And the family, my lord, solely dependent on the fair price shop, my lord. Here in this case, my lord, I am relying the paragraph number 18, 19, 22, and 28, my lord. Here in this case, my lord, the petitioner is, my lord, petitioner mother run, my lord, fair price shop, my lord, and she is a married daughter, my lord. That is why the Allahabad High Court has dismissed her writ petition, my lord, and the Apex Court had stated in the paragraph 18, 19, and 20, 22, my lord, that the married daughter, may I read, my lord, paragraph 18, my lord?
Yes.
Examine on the touchstone of these principles, the exclusion of a married daughter from the definition of family cannot be sustained. The object of allotment under the dependent quota is to provide immediate succor to the family of a deceased dealer facing financial hardship. The relevant considerations are dependency, financial need, residence, and the ability of the applicant to discharge the obligation attached to the dealership. Marital status bears no rational nexus to any of these considerations. And paragraph 19, the impugned provisions proceeds on the assumption that upon marriage, a daughter ceases to be a member of or dependent upon her parental family. Such an assumption is constitutionally impermissible. Marriage neither extinguishes the bond between a daughter and her parental family nor furnishes a valid basis to presume absence of dependency. Contemporary social realities demonstrate that many married daughters continue to reside with support or remain dependent upon their parents. Equally, there may be sons who are not dependent upon the family despite being included within the definition. Dependency is a question of fact and cannot be conclusively determined by reference to marital status alone. And further, my lord, paragraph 22. May I read, my lord?
Yes.
The purpose of dependent quota is neither to create a right of succession or inheritance in the dealership nor a reward for lineage. The object is limited and specific: to provide immediate financial relief to the dependent family of a deceased dealer and to ensure continuity in the public distribution system. Once dependency is accepted as the governing criteria, exclusion of a married daughter solely on account of her marital status becomes wholly irrational and self-defeating. And the final conclusion, my lord, paragraph 28.
Yes.
In the present case, the material on record establishes that the appellant continued to reside in the same village even after her marriage and actively assisted her mother in the operation in the fair price shop. The appellant, upon her mother's demise, assumed responsibility for maintaining her sisters, including visually impaired sister. The authorities have not disputed these factual assertions. The sole ground on which her application was rejected was that she is a married daughter. Once that ground is held to be constitutionally invalid, no impediment survives to the grant of relief in her favor.
Is there any scheme under the Assam Act?
No, my lord.
There was a scheme under the UP Act for compassionate appointment. Do you have a scheme here in Assam?
In regarding fair price of, my lord.
Yes.
That I don't know, my lord.
No, no,
Government.
that you have, that is your case. You are depending on relying upon a case
Yes, my
where
lord.
there was a scheme.
Yes, my lord.
And to include in the meaning of family, married daughter has been included.
Yes, my lord.
That is the law.
Yes, my lord. But
So the basis is there has to be a scheme
yes.
to give to a dependent family member if the fair price shop licensee passes away.
Yes, my lord.
Now, is there any scheme of that nature in so far as Assam is concerned?
Nothing has been brought forth, lordship, by the.
First, there is to scheme. You apply under the scheme that I am the widow.
Yes.
Kindly give it to me.
Yes, my lord.
In absence of a scheme, then also there may be a case made out by you.
Yes, my
But
lord.
you cannot depend upon this Supreme Court.
Yes, my
Supreme Court was in session of a matter where there was a scheme in the UP state,
Yes,
state of
ma'am.
Uttar Pradesh.
Yes, my lord.
And only because she was the married daughter of the license holder, it was denied.
Yes, my lord.
Supreme Court said that you give a broad meaning to the
Yes.
to the expression family, include
Yes.
a married daughter, look into the facts and circumstances and give. Here your case is not similar. Facts are totally different.
My lord, yes, my lord, but only, my lord, that on cabinet decision, my lord, 19/10/2021,
Page.
not in that, my lord, only I am relying on that day, my lord, Nurul Islam, my lord.
Which?
2023, my lord, that the cabinet decision.
Where are you reading from?
This one, my lord.
What is that?
Nurul Islam 260/2023. In this case, my lord,
Yes.
widow and physically disabled person have been.
That is in the context of 40/50.
Yes, my lord.
Not in
But-
this context.
Yes, my lord, but they have filed an affidavit that my because I have less than 50, my lord, they have attached my fair price up to nearest one, my lord.
That you cannot do. But that will not solve your problem, madam.
Yes,
The name, the license will still be in the name of your deceased husband.
yes, my lord.
License has to be considered. We can give a direction, but you cannot depend on this decision.
Yes,
See, to deal with sympathetically in a compassionate manner, that can be a direction, but it will not be based on any statute or any scheme.
yes, my lord.
Yes, what do you say, Mr. Talukdar?
Lordship, that fair price shop has already been attached with the nearby shop having Lordship as because they have less than 50 ration cards, Lordship, as per the cabinet decision.
See,
And that decision is fortified by our Honorable High Court, Lordship, in the case of Vijay Vara, Lordship.
No, that is okay. We have upheld the cutoff 50.
Lordship,
But here is an exception where an widow is making the prayer.
Lordship.
And you have also, in the case of Nural Islam, this court has said that so far as specially able and widow is concerned, you give some concession to that.
Subject to fulfillment of all the requisite criteria.
Requisite. You don't be very strict on the 50 criteria. But here that will not solve her problem. The license is yet to be transferred to her name. For that, you need to make a consideration. Have you applied for transferring the license?
Yes, my lord, they have rejected and I have made representation.
Where is the rejection?
Rejection order, my lord, I don't have, my lord, but
Lordship, my submission would be, as a matter of right, they cannot lay their claim.
No, you're correct.
But then it is only a
but
matter of
it's sympathy
compassion.
ground, my lord, on my
where is
limited
where is your statement that it has been rejected?
And that rejection order, they have not said it.
No, that madam has said she doesn't
My lord,
possess that.
verbally they have told us that.
Where have you stated?
They have to send it there.
Have you stated anywhere?
My lord, I have only submitted my representation, my lord.
Then you have just made a statement, it has been rejected. Pointed query of the court, where is the rejection? You said I do not have, but it has been verbally done. Then where is the pleadings of verbal rejection? You need to focus on the issue, madam. You have gone astray. You are not focusing on the issue. Why have you come to the court? You should know. You focus on that.
My lord, on paragraph 8, my lord, page 7.
Page 7.
Yes, my lord.
Yes.
Yes, my lord. The petitioner, my lord, from the bottom 3 line, my lord, from the name petitioner husband to the name of petitioner on compassionate ground, yet the respondent authorities, more particularly respondent number 4, had not considered the case of the petitioner till date. The petitioner further states that respondent authorities, more particularly respondent number 4, had been
That is not rejection. That is rather
verbally
making a submission that you have been assured that it is being considered. Yes, Mr. Talukdar. The instant application under Article 226 of the Constitution of India has been filed seeking the following relief. Please have your seat, madam. Mr. Arul, have a seat. As per the facts projected, a fair price shop license number NHG देख लीजिए हाँ 118 under the Assam Public Distribution of Articles Order 1982 was duly allotted in the name of the husband of the petitioner, Bhubaneshwar Sharma. Full stop. The said license was renewed from time to time and the business was in operation. Full stop. However, unfortunately, on 18/8/2020, the husband of the petitioner expired, leaving behind the petitioner and a specially able son who were wholly dependent on the business of the fair price shop. Full stop. The petitioner had thereafter represented before the authorities for transfer of the license, which was not done. Full stop. On the other hand, on the ground that the number of consumers were less than 50, the consumers have been attached to a nearby fair price shop. Full stop. the representation of the petitioner having failed to yield any results, the petitioner has approached this court for the relief as mentioned above. Para. I have heard Ms. R.S. Dury, learned counsel for the petitioner. I have also heard Sri R. Talukdar, learned state counsel. Full stop. Para. Ms. Dury, the learned counsel, has submitted that so far as the aspect of attaching the consumers to on the ground of having 50 or less than 50, having 50 or less numbers of ration cards, though there is a cabinet decision which has been upheld by this court, this court in the case of Nural Islam versus State of Assam, WPC 260/2023, wide judgment dated 4/8/2023, has submitted, has held that such a prescription has to be condoned if the license holder is a widow or a specially able person. Full stop. She has also submitted that the Honorable Supreme Court in the case of Kulsum Nisha versus State of UP and others, reported in AR 2026 SC 2739, has held that even a married daughter would come within the definition of family insofar as grant/transfer of fair price shop license is concerned. Full stop. Para. Sri Talukdar, the learned State Council, has however submitted that affidavit in opposition has been filed on 24/9/2024, and he has justified the action as the number of action as there is no scheme as such for transfer of a license to the family members. Full stop. He has also submitted that the attachment of the consumers, of the ration card holders to the nearby shop has been done in view of the cabinet decision. Full stop. Para. The rival submissions have been duly considered. Para. It is not in dispute that the license in question was allotted in the name of the petitioner's husband in the year 1982, and the business was being run by her husband without any blemish. Full stop. The husband of the petitioner had unfortunately passed away in the year 2020, whereafter it appears that the petitioner had paid for transfer of the license, grant of license in her name. Full stop. Para. Though the learned counsel for the petitioner has not been able to show any particular scheme or norm or rule which would require transfer of such license to a family member, under the facts and circumstances of the case, more particularly in view of the fact that the petitioner, who is a widow, has a specially abled child, the application of the petitioner is required to be considered in the proper perspective. Full stop. Where is your representation, madam?
My lord, page 26-27.
It is accordingly directed that who will make the consideration that the
Director of Food Civil.
who will make Mr.
Respondent number 3.
Two lordships, respondent number.
Deputy Director.
Lordship, let it be to the concerned authority.
The concerned respondents would consider the representation of the petitioner, which is stated to be pending, and pass appropriate orders by taking into account the observations made above. Full stop. Such disposal, such consideration and disposal be made expeditiously. And in any case, within 4 weeks, within 6 weeks from the date of receipt of a certified copy of this order, full stop, the aspect that the petitioner, being a widow, would be exempted from the cabinet decision regarding the numbers of ration holders would also be taken into consideration while disposing of the said representation. Full stop. Petition is accordingly disposed of.
Obliged.
Milord, sorry, in serious case, our name may be shown, Milord.
We are not showing your name. We have said none appears. None appears to cut. You should be there.
Milord, we think, Milord, there is a flood area, Milord, that's why.
Flood. Okay, for flood, everything is, even the court is affected.
Yes. Obliged.
Who cut this? Mr. Chaudhary, how's the situation in your place? You are safe.
If my place is affected.
You are safe.
Guwahati will
Guwahati
be
will-
in a difficult position.
You are safe.
Yesterday it was too heavy.
Nonetheless,
Last minute, 10 start from.
many
10.
things can be said, but not to say anything.
Netherlands fund has been engaged by government of Assam. I filed a PIL bill.
Netherlands is supposed to have the best experts because Netherlands, it's
Netherlands is expert on another field.
because Netherlands is below the sea level.
No, yes. But
So,
this is urban drainage is a different concept.
but nonetheless, let us hope for the best. Netherlands has an exception. It's below the sea level. Still, they are managing.
Something like Dibrugarh.
Yes.
Minute.
No, Miller, there are two matters here listed before your lordship.
Hmm.
One is WPC 6142, that may be taken up first, my lord.
Okay. We are taking for disposal.
My lord.
Six one four two. You want to take?
My lord. Division bench foundation. 72 by 20.
Yes.
My lord, in 6142, your lordship may kindly come to page 14,
14.
14, my lord. This is your lordship's own order. There are two writ petitions in which judge order and judgment was passed by your lordship,
14.
page 14.
Yes.
My lord may directly come to the operative part of the order is at page 24.
What is the date of the order? There are two writ petitions.
There are two writ petitions, my lord. These orders were passed, my lord, 6/9/2024.
6/9/2024. Yes.
My lord, in the operative part of the order, there was a contract for running the catering services of the Indian Oil Corporation Guest House in 6 Mile.
Yes.
My lord, this contract pertain to supply of food, catering services, housekeeping, everything. And my lord, a dispute arose as to who would work there. As per the contract, my workers were supposed to run the catering service, but the IOC respondent said, no, we'll employ our own workers, and you need not employ your workers, we'll employ our own workers, so you need not come. So that was a dispute. We came to the court, my lord, our contract was terminated, against which we had filed writ petitions, 6954.
Earlier or this time?
Earlier, my lord.
69, see,
This is our outcome is this order. We are at page 24 is the relevant portion of the order.
24.
Page 24.
No, that's 69, this is 6596.
And 3804.
3804.
Both.
Okay. Your contract was terminated.
Terminated.
That was the subject matter of challenge.
My lord,
Okay.
in 6954.
Yes.
In a lordship's order at page 24, my lord, the operative part,
Yes.
if I may read it at para 17, page 24.
Hmm.
In view of the aforesaid facts and circumstances, this court is of the opinion that a case for interference is made out. Accordingly, the termination order dated 6/11/2023 is interfered with. Consequently, the respondent refinery is directed to allow the petitioner to complete the contractual liabilities in terms of the work order dated 29/3/2023. It is also made clear that the respondent refinery cannot restrain the petitioner from engaging its own men for discharge of duties, my lord. It's para 17.
Hmm.
At para 18, my lord,
Yes.
this is why this present writ petition 6142 has been filed. Since the contract was for 2 years, and because of the issue involved, the petitioner could not discharge the same, the petitioner would have the liberty to file application for allowing to discharge the functions for the full term, and in case such application is made, the same would be considered by the respondent refinery in accordance with law, and by passing of a speaking order, both these writ petitions are accordingly stand allowed. Both these writ petitions accordingly stand allowed. Now,
Hmm.
para 18, my lord, the lordship is the full term was for 2 years.
Understood.
Lordship had allowed us to make an application. So, my lord, in the next page, at page 25, annexure 2, we made an application accordingly.
In terms of the observations made in paragraph 18.
18, my lord.
Yes.
Annexure 3, page 27 is there, speaking order, so-called speaking order.
27.
Page 27. It starts at page 27.
Hmm.
The relevant portion, my lord, at page 28.
Yes.
I may read it, my lord, at page 28.
Yes.
Whereas the above work order commenced on 1/5/2023 as per acceptance of GEM contract, following the kickoff meeting held on 25/4/2023, SH Enterprise have agreed to start the job on 1/5/2023 and started execution of job from 1/5/2023. But SH Enterprise have failed to carry out the job of running the services of the guest house 6 Mile Gauhati, following which so-called notice had been served to SH Enterprise for leaving the work site and failure to carry out the execution of the
Yeah,
contract.
that is okay. Being aggrieved, the said termination, file writ petition, then come to the later part.
Whereas the Honorable Gauhati High Court, by judgment dated so and so, set
Yes,
aside the
thereafter.
termination order.
Now, in view of the above, we are hereby directed to complete the contractual obligation.
For 6 months.
Okay.
My lord, where is the law involved here? Where is the speaking order, my lord? There has to be reasons given as to why my 2-year full contract has been rejected. My prayer for two-year contract.
It is not for 2 years.
No, my lord.
How many? What
6
is it?
months. The remaining part of 5-6 months, they have allowed us. But my lord, the main issue involved here in this so-called speaking order is that there's no speaking order, there's no law. It is arbitrary non-application of mine, total non-application of mine. They have to state reasons why my 2-year full contract was rejected.
But there's a writ appeal.
The
Writ-
writ appeal, my lord, what has happened? When this issue 6142 was pending, the IOC has been delaying this, the hearing of 6142.
Mm.
In the meantime, what they did, they floated a new tender for allotment of the catering services to, it was an open bidding. So we came to the court under WPC, the second writ petition, WPC 738. We
Which
obtained a stay from this honorable
Which
court.
738?
738 is the next writ petition. This is
There are two, okay, 738, okay.
738, my lord, is the writ petition against the floating of the new tender,
Okay.
while this 6142 was pending.
Okay.
And in 738, my lord, this honorable court was pleased to stay the floating of the new tender.
Okay.
My lord,
What is this writ appeal?
I'll come to that. When 78, then the respondent authorities, they filed for vacating of the interim order. The vacating of the application. for-
Just a minute, please. Just a minute. Okay. IOC paid for vacating.
Vacating. They filed an application for vacating the stay order in 738.
Hmm. Yes.
That was rejected by this honorable court.
Okay.
My lord, against it, my lord, the respondent IOC went on appeal.
Okay.
That is where writ appeal 152 of 2005
Writ appeal 152.
of 2025.
Okay. What happened there?
But at para 34,
Page?
I'll
It was.
at para 33, my lord,
Page?
page 13.
One three.
Below, my lord, para 32.
Yes, yes.
In the present case in hand, the appellants have to provide catering services to the guests in the Gauhati guest house and to employees and the visitors in the Gauhati office. If such service is not allowed till the two writ petitions filed by the respondent, that is writ petition 6142 and writ petition 78 are decided, the essential service to guests and employees will suffer. 34. Be that as it may, as the common judgment and order dated 6/9/2024 referred above has attained finality, and moreover, the respondent has already assailed the speaking order dated 22/10/2024 by filing WPC 6142 of so and so, and has also assailed the tender dated 15/2/2025. The court is of the considered opinion that the interest of both sides would be protected by conditionally interfering with the order dated 26/3/2025 passed by the learned single judge in IA number so and so by directing the finalization of NIT dated 1/2/2025 as a and the resultant contract, if any, shall be subject to the outcome decision of the court in WPC 6142 and WPC number 78 of 2025. In other words, while settling the tender work with a successful bidder in NIT dated so and so, before entering into the contract agreement with the successful bidder, the appellants shall make it clear to the successful bidder that the contract would be subservient to and or subject to the decision of this court in WPC 6142 and WPC 738.
Yes.
In the said manner, the interest of the appellants as well as that of the respondent would be protected, and the two writ petitions so and so and so and so filed by the respondent would not be frustrated. Accordingly, the appellants are directed to file an affidavit in the said two writ petitions that they made the finalization of NIT dated 1/2/2025 and resultant contract agreement subservient to and or subject to the decision of the court in WPC 6142 and WPC 738. Such an affidavit shall be filed within a period of 2 weeks from the date of the order. And the last page, my lord. Accordingly, the impugn order dated 26/2025 has been conditionally interfered with. Thus, it is made clear that unless and until an affidavit as directed herein above is filed, the order dated 26/3/2025 passed by the learned single judge in IN number so and so shall continue to hold the field. The stay by interim order dated 12/2/2025 passed in WPC 738 shall stand vacated as and when the affidavit as directed above is filed by the competent authority of the appellants. This is already at the last paragraph at para 39, my lord. Before parting with the records, it is also clarified that any observations made in this order is limited to this order, and as the merit of the case of the parties is in the pending writ petitions have not been gone into or entered into, hence none of the parties to the said to writ petitions shall suffer any prejudice whatsoever when WPC 6142 and 738 are heard and decided on its own merit without being influenced by this order. This intercourt conditionally disposed of. This intercourt is conditionally disposed of on terms and to the extent as indicated above. The parties are left to bear their own cost. So, my lord, this is conditional, and we have already implemented the successful bidder.
The new NIT has been finalized.
Finalized, it has been allotted to a successful bidder, and we have made him a party in 738, my lord. He has been served, but he has not appeared.
No, even if he appears, it is made clear that it will depend on the outcome.
Outcome of this two petitions.
Okay.
So, my lord, my case before my lord is now here is in 6142. In this, what is the speaking order? Where is the law? How has it been passed in accordance with law? I don't have to show it's very apparent on the face of the record. Where is the application of mine? Where are the principles of natural justice? In fact, it is a travesty of justice that this kind of order is passed, because my lord cannot even go into this order, speaking order, because it is not a speaking order. If it had been done in accordance with law, then my lord would have had the opportunity to dissect the speaking order. But here, there's no speaking order, no reasons given, nothing. They just say that, okay, as per this order, we are giving you 6 months or 6 months more, you take over for 6 months. Now, I have invested, this contract is worth over 2 crores. I have invested, I've taken loans, I've employed those workers, I have to pay them, Where will my money, how will I make up in 6 months' time, my lord? The balance of convenience should have been in my favor.
The new allotee has been notified with this clause of the.
It is incumbent upon them as per the writ appeal.
That has been done.
I know.
Oh, that is your case.
6142, my lord, it's not a speaking order.
Okay. Yes, Mr.
I think there is a fundamental fallacy in the entire case. Also knows in Damodar Valley Corporation, Supreme Court has clearly said, my lord, once the period of contract has come to an end, it does not survive for performance. If there is any dispute which has arisen during the period when the contract was alive, then those can be, basically either he has to go for arbitration or he has to file a civil suit claiming damages. I don't think, my lord, lawsuit will permit him to, operate the contract after the contract period is over. If a lawsuit will kindly have the judgment, my lord, only that point, my lord. 1974, 1 SCC, page 141. Please come to para 8, my lord, at page 145. At page 145, para 8, my lord. In certain circumstances,
Yes.
it may be that there has been termination of contract unilaterally, and as a consequence, the parties may agree to resign the contract. In such a situation, a rescission would put an end to the performance of the contract in future. but it may remain alive for claiming damages, either for previous breaches or for the breach which constituted the termination. Lord, in my humble understanding, my lord, it is the fundamental principle, my lord. Once the period is over, then, my lord, the contract does not survive for performance. And in any case, my lord, these are all disputed questions, my lord. He started operation from 5th of May. Then he, my lord, he operated for 1 month or so. Then he said, I will engage my own laborers. Therefore, my lord, he did not render his service. Eventually, show cause notice was issued. Eventually, it was terminated. Then your lordships interfered with the termination. Then, my lord, liberty was given to the, we have permitted him to work for the unexpired portion of the period, and he did not do. He did
But-
not do
but
anything.
what
And
about-
even like
but-
in the second tender, he did not participate also. In the second tender. In the second tender, he has not participated. Whether without participating, my lord, whether he can even assail the contract now which has been given on 2/8/25 to the successful bidder. But your lordship has passed a judgment that has attained finality. We have not filed any writ appeal. So now the consequence is, my lord, assuming there is something wrong in our conduct, my lord, it has to be quantified as a damages in an appropriate forum. I don't think your lordships will, exercising 226 powers, will extend the contract, my lord. That
No,
is-
Mr. Chaudhary, this submission of yours by relying upon Damodar would have been
Damodar Valley
a submission which requires consideration while disposing of the original writ petition. Whether there can be a direction to give them extension after the period is over.
There your lordship has not committed any error because the unexpired period was there.
No, but nonetheless, the
Your
observation,
lordship did not give any mandamus that it should be given.
no,
Lordship
the
has only indicated-
observation
yes, yes.
was not for the unexpired period.
No, for
Observation,
consideration.
observation was for consideration.
Yes, please come to para 18, my lord.
18 years.
Since the contract was for 2 years and because of the issue involved, the petitioner could not discharge the same. Petitioner would have the liberty to file application for allowing to discharge the function for full term. And in case such an application is made, same would be considered by the respondent refinery in accordance with the law and by passing a speaking order. Now let us see whether we have passed a speaking order.
Yes, page 28,
Yes, please come to page 27, my lord.
27 years.
Last part. Whereas GM contract dated for providing catering and other services at BGR Gauhati Guest House and Complex at Jayanagar 6 Mile by the work order dated so-and-so was awarded to SH Enterprise as per the terms and conditions of the contract, and duration of the contract was for 2 years, 2 years from the date of handing over sign. Whereas the above work order commenced on 1/5/23 as per acceptance of the GM contract. Following the kickoff meeting held on 25/4/23, SH Enterprise have agreed to start the job on 1/5/23 and started execution of the job from 1/5/23. But SMH Enterprise have failed to carry out the job of running the services of the guest house, following which show cause notice had been served to Messrs. SH Enterprise for leaving the work site and failure to carry out execution of the contract. And subsequently, termination notice of the contract was issued to SH Enterprise on 6/11/23. Being agreed by the said termination, SH Enterprise filed the writ petition, whereas the Honorable High Court by judgment in order set aside the termination order dated 6/11/23 and allowed SH Enterprise to execute the job as per work order dated to complete the contractual liabilities of the contract. Now, therefore, in view of the above, you are hereby directed to complete the contractual obligation of the contract for remaining period.
But
of
where is the
contract.
consideration of the direction pursuant to which he had made the application? You can reject it,
Yes.
but there is no rejection, there is no consideration at all. He had made out a case that it's a huge contract, I could not perform. So let me perform. Court said that you can file an application, you will be the best judge. You have to consider that for this reason we are not giving you, for this reason we are giving you. That is not
Reason
coming.
is indicated in the first para, my lord, that
Where?
where you started the job from 1/5, but have failed to carry out the job. First,
That was the subject matter of consideration, the first writ petition.
so my lord,
We had interfered with the
no,
termination.
my lord, end of the day,
Yes.
whether your lordships exercising 226 power would extend the contract.
No,
As
we-
prayed
we-
by the petitioner.
We have not at all.
But his prayer is that
No, no,
only.
he's not at all. We have not at all.
His prayer is
No, no,
that.
he can play anything. We are not.
My humble submission is, my lord.
We will not
Yes.
play. We will not play the role of IOC.
Yes.
You are the owner,
Huh.
but you have to act fairly.
Yes.
There was a direction to consider his application because he said that he has suffered loss or not. We do not know whether it's correct or not. You consider on the relevant factors. You have not even considered anything.
My lord, yes.
Lacking. That entire thing is lacking. For 6 months, that was not even the consideration, whether he give for the remaining 6 months. But
Now, assuming, my lord, a mind is applied and the authority comes to a conclusion, there were some lapse on the part of the authority. Even then, my lord, he cannot be given. So you will not
you-
be a
you-
useless
you-
formality, my lord.
no, you state it on paper, you convey it to him. After all, you are a public authority.
Richard, that, my lord. But only thing is, my lord,
No, this
ultimately it boils down to his right to continue beyond the period of the expiry.
that you have to take a call. We did not say that you have to give him for 2 years without any.
That lordship never said.
22nd October 24 order, I think is a very cryptic order.
No, but my lord,
At least you give one paragraph consideration.
true.
You write
Ideally,
2
they
pages
could
of
have prepared-
prelude, then you say that 6 months remaining will.
My humble
Why do you
submission,
reject for 2 years?
now third party rights has been created.
No, that the division bench has taken care of. You take care of this, and your decision will be will govern your the third party rights which have not accrued. It's a conditional right. As
If your lordship would kindly have the order dated 19/1/26, my lord,
in which case
in the second case,
in 738.
first case.
Seven three eight.
Yes, what is it, my lord? Anyway, my lord, there was a direction to submit amended cost title, whether it was that position. It is done, my lord.
No, that apart, even if it is not done,
No, no.
order of this court is very clear. Division
No,
bench.
my only humble submission is, my lord, whether, my lord, in the garb of expecting a speaking order, the petitioner can, my lord, get an order which will, my lord, entitle him to an.
No, we are not on that. We are only on the aspect of a fair consideration. Fair consideration to the relevant factors and pass a speaking order as directed by this court. And this way, adoption of this manner, we don't endorse.
May I
this.
take just 2 minutes, my lord?
Yes,
My lord, at page 19, my lord, at 6142,
page 19.
page 19. This is part of my lord's order.
Yes,
It starts at para 8, my lord,
yes.
page 19.
Hmm.
On the aspect of maintainability of the writ petition, the learned senior counsel for the petitioner has placed reliance upon the cases of MP Power Management Company Limited, Jabalpur versus Sky Power Southeast Solar India Private Limited, reporting so and so. Well, and ABL Industries. Now, my lord has observed here because it is not that I could not perform the contract, part of my contract. I was not allowed to perform my contract. That is observed in my lordship's order. At page, my lord, 23, my lord, para 16, as regards the question of maintainability is concerned, no serious issues were raised on behalf by the respondents. In any case, the
Mr.
honorable-
Sharma, Mr. Will not go back to the discussion.
No,
The other issues have crystallized into this order of
My lord.
6/9/2024.
strictly contrary to
Termination has
614.
been set aside.
No, but I object to my learned friend's reference that I could not complete the
No,
contract.
that.
I was
will
not
be-
allowed to complete
will
the
be, no,
contract.
those will be,
I
this,
said these are all disputed
this is,
questions of
exactly,
fact.
that is what this will be within the realm of questions of fact. You'll be given a scope of hearing, you, in the speaking order, and you pass a speaking order, okay?
Until then, my lord, the other arrangement will continue.
And that will continue
Yes.
till, that has been already been.
Yes.
Yeah, noted.
And my lord, the respondents may also consider giving me a compensation.
That for
can be
you,
left open, my lord.
we'll keep it open. We'll keep it open.
Because
And that we cannot speculate now.
I'm aware of that.
You cannot speculate now.
I'm aware of that.
They may act in your favor, which is not possible, I think.
No, that I already indicated, my lord, you told you have a cause of action, you have a cause of action for that.
If you want, you can leave, Mr. Chaudhary.
Yes.
We'll interfere in this
Yes.
and we'll ask you to press consideration,
Liberty to pass a
fresh order, but strictly
Yes.
as per the observations by this court.
Yes.
And then while giving that, give him an opportunity of hearing.
And secondly, my lord, the other.
And all the decision the further decision will depend on the outcome. Okay.
Yes.
Both these two writ petitions being connected are taken up for an analogous hearing and are being disposed of by this common judgment and order. Full stop. As the facts as projected in brief are that a contract for catering services at the IOC Guest House 6 Mile was granted to the petitioner, which amongst other included housekeeping and the canteen and running of the canteen.
Catering services.
Also
Canteen and housekeeping services also.
into housekeeping. Full stop. The issue had, however, arisen as to who will employ the workers, and on that issue, the contract was terminated on 6/11/2023. Full stop. The petitioner had filed two writ petitions, being 3804 of 2023 and 6596 of 2023. Full stop. Both the writ petitions were heard and after consideration were disposed of vide a judgment and order dated 6/9/2024. Full stop. The termination order dated 6/11/2023 was interfered with. Full stop. Further, comma, on the submission made on behalf of the petitioner, comma, liberty was granted to the petitioner to submit appropriate application for allowing to discharge the functions for the full term as per the contract. Full stop. It is the case of the petitioner that such application was accordingly submitted on 17/9/2024. Full stop. However, comma, vide the impugn speaking order dated 28/10/2024, comma, however, comma, however, an order dated 28/10/2024 has been passed, whereby the petitioner has been allowed to perform only for the remaining 6 months, and there was no consideration regarding the aspect of the full term of the contract. Full stop. In the meantime, comma, on 1/2/2025, a new tender notice was issued, which is the subject matter of challenge in the second writ petition 738 of 2025, and this court had passed an interim order. Full stop. The matter reached the Honorable Division Bench through an appeal filed by the IOC, and the same was disposed of by an order dated 17/7/2025, whereby it was clarified that though there would be no blanket interim order, a blanket stay on the new process, any allotment made with the third party would be subject to the outcome of the writ petition. Full stop. Para. I have heard Sri R. Sharma, Learned Senior Counsel, assisted by Ms.
P. Fukan.
P. Fukan for the petitioner. I have also heard Sri K. N. Chaudhary, Learned Senior Counsel, assisted by Ms. R. Kakoti for the IOC. Para. Sri Sharma, the Learned Senior Counsel, has submitted that the impugned speaking order cannot be termed as a speaking order, as there is no consideration at all to the directions of this court made in the judgment and order dated 6/9/2024. He has submitted that there was a specific direction of this court to consider the request of consider the case of the petitioner on his application to discharge the function for the full term, inasmuch as for reasons disclosed in the writ petition, the petitioner was not able to run the business. Full stop. He has submitted that while in the impugned order there is a prelude of the background facts and circumstances, there is no consideration to the aforesaid prayer, and in a cryptic manner a mere observation has been made allowing the petitioner to discharge the contractual obligation for the remaining period of the contract. Full stop. He has submitted that the notice dated 1/2/2025 under those facts and circumstances for grant of a new contract is clearly in teeth of the said direction, and accordingly WPC 738/2025 has been filed, in which an interim order was passed. He has highlighted that though there was an application for vacation of the interim order, such application was rejected, whereafter the IOC had preferred writ appeal WA 152/2025. Full stop. He has, however, submitted that the Honorable Division Bench, by the order dated 17/7/2025, though has given the clearance to the IOC to go ahead with the new process, the same has been made conditional upon the outcome of the present two writ petitions. Full stop. The Learned Senior Counsel for the petitioner has reiterated that the impugned order dated 28/10/2024, apart from being unreasonable and arbitrary, is also in defiance of the clear direction of this court made in the judgment and order dated 6/9/2024. Full stop. Para. Per contra, Sri K. N. Chaudhary, Learned Senior Counsel for the IOC, has submitted that the relief prayed for in the two writ petitions are fallacious, and if at all there is any grievance, the petitioner has to approach the appropriate forum for damage. Full stop. He has submitted that once the period of contract is over, no right would exist upon the contractor to demand that he should be allowed to work beyond the period of the contract. Full stop. It is also submitted that in the new tender process initiated wide notice dated 1/2/2025, comma, the petitioner did not even participate. Full stop. Para. In this regard, comma, the learned senior counsel for the respondent has relied upon a judgment of the Honorable Supreme Court reported in 1974, 1 SCC 141, Damodar Valley, Swediba, and the observations made in paragraph 8 are pressed into service, which read as follows. Paragraph 8, quote Kurijiba. Para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Full stop. The termination of the contract dated 6/11/2023 was the subject matter of challenge in the earlier two writ petitions, which was disposed of wide order dated 6/9/2024. Full stop. While this court had held the termination to be not in accordance with law and had accordingly interfered, comma, a further observation was made regarding consideration of the case of the petitioner to discharge the function for the full term. Full stop. As mentioned above, comma, the term of the contract was for a period of 2 years. Full stop. For any reference, comma, the observations made, relevant observations made in the order dated 6/9/2024 are extracted herein below, page 24, 17 and 18. Full stop. Sri Sharma, the learned counsel for the senior counsel for the petitioner, has emphasized that the contract is a huge one in which he had made sufficient investments, and therefore, under those circumstances, comma, the prayer was made for consideration of his prayer, of his request for allowing him to discharge the function for the full term, based upon which the observations made above were made by this court in paragraph 18. Para. It is not in dispute that the petitioner had accordingly made a request via intimation dated 17/9/2024 to allow him to discharge the functions till the full term. Full stop. The impugned order dated 22/10/2024 has, however, simply allowed the petitioner to complete the remaining period of the contract up to 30/4/2025. Full stop. On a careful reading of the impugned order, comma, it does not transpire at all that there has been any consideration at all towards the request of the petitioner to allow him to function for the full term, which was one of the directions passed by this court in the judgment and order dated 6/9/2024. Full stop. While the IOC authorities have stated the background facts and circumstances as prelude, comma, there is no consideration towards the direction made by this court in paragraph 18 of the judgment dated 6/9/2024. Full stop. Full stop. It also appears that the subsequent action of the IOC in initiating a fresh tender process via notice dated 1/2/2025 is the subject matter of challenge in the second writ petition WPC 738 of 2025, wherein there was an interim order, which was also not vacated, full stop. Nonetheless, the Honorable Division Bench in WA 152 of 2025, wide order dated 17/7/2025, has clarified the issue that while there would be no restriction in the new process, any allotment done would be conditional to the outcome of this petition, full stop, para. This court, full stop, para. So far as reliance upon the case of Damodar Valley Corporation, Supra, is concerned by the respondents, there is no dispute to the proposition laid down that in case of a termination of contract unilaterally, an aggrieved party can only claim damages, full stop. This court is, however, of the considered opinion that it is not the termination which is the subject matter of challenge, and in fact, such termination dated 6/11/2023 was already interfered by this court in the judgment and order dated 6/9/2024, which has not been put to any further challenge and has attained finality, full stop. This aspect has also been taken into consideration by the Honorable Division Bench in the order dated 17/7/2025. Para. In view of the above, both the writ petitions are disposed of by setting aside with the order dated 28/10/2024 and by directing the IOC to give a fresh consideration to the request of the petitioner to allow him to function for the full term as per the contract initially granted to him, full stop. Such consideration has to be made by taking into account the relevant factors, including the aspect of the investment said to be made by the petitioner, full stop. While making such consideration, the petitioner, the representative of the petitioner / his representative is also required to be given a personal hearing, full stop. Let the aforesaid exercise be undertaken and completed within a period of 6 weeks from today, and the outcome of such consideration be communicated to the petitioner in writing, full stop. The aforesaid outcome would also determine the new contract given given pursuant to the notice dated 1/2/2025, which is already made conditional as per direction of the Honorable Division Bench of this court. Okay.
Obliged.
Item 5, what is this, Mr. Chaudhary?
May I please, your lordship? This is a matter relating to a manufacturing license of guns.
Of
Guns.
guns. Okay. Oh, yes.
And from transfer from the father to a son.
Okay.
My lord, what has happened in this case? The father of the petitioner,
We are for final disposal.
Lord,
As it is, I will just point out.
otherwise, my lord, pleadings are complete.
Now, if you are agreeing, then we take up for final disposal.
Yes, my lord, because
I will just point out. That has not come out in the petition. Detail. They are brothers. The petitioner, he has got 2 other brothers. Another brother's case is pending before the division bench.
He is also making the same. Oh, is it?
No, he was, my lord, he included his name along with our father in the license, my lord. Thereafter, his,
But it's the same cause of action,
no, my lord,
connected cause of action.
no, my lord.
Now, if you succeed, then what will happen to a DB?
In fact,
Suppose you succeed, there is an order direction to give you the transfer the license. The DB case will be become infructuous.
No, my lord, because my lord, all the sons, legal years, they are entitled, my lord, after death, because
Now, how many
our father,
Mr. Sen,
Our
whom are you representing? One of the sons.
one of the son,
The other, your brother is before the division.
one brother, my lord, expired,
One is there.
Shekhar Kishore Kanu, he expired, my lord. Now,
When is that matter fixed?
it's a fixed date as
Do you have the number?
I can provide the number.
Please have this. It will not be proper to adjudicate. Has it been
No,
disclosed?
My lord, our only prayer is, my lord, we filed an application before the authority for inclusion of our name
It is?
in the
still
license.
in the stage of IA, there was a delay. IA number,
And what happened to the writ petition?
writ petition was closed by Honorable Justice Pathak with a direction that the petitioner there will find a representation before the authority and authority will consider it. Now authority has considered it. The brother is before the division bench saying that he was not made a party in the writ petition.
Or
So one brother is not making the other brother party. So
no, what about this brother?
The
not
Huh?
question here,
that was Shekhar Kishore.
No, he has passed away, he said.
Shekhar Kishan now passed away, my lord,
Maybe
to my
recently.
information, yes.
Maybe recently. Not sure.
But
He
it
has
appears
passed
that there is a clash of interest between the brothers.
Yes.
But
In that earlier writ petition, were you a party?
no, my lord, we have
Oh.
not been made party. We have not been. Subsequently, we came to know,
I
my
think
lord,
this
when we have filed-
there has to be, if not an analogous hearing, at least there has to be some observations. We'll make it clear now. Heard
My-
Sri B.K. Sen, learned counsel for the petitioner. Also heard Sri R.K.D. Chaudhary, learned senior counsel, appearing for the Union of India as deputy SGI. Para. Sri Chaudhary, the learned senior counsel, has however informed this court that the issue involved in this case, which is towards transfer of an arms license, arms or manufacturing license, transfer of an arms manufacturing license.
the inclusion and endorsement of my name
Okay.
in the license, not transfer. It is not transferable.
Which involves ki? Involves? Nataragot. Towards inclusion
Inclusion and endorsement
and
of the
endorsement of the name of the petitioner
petitioner
in the arms manufacturing license, comma,
in place of his father, my lord, who
in place of
expired.
his deceased father, comma. Another brother of the petitioner had already filed a writ petition, which was disposed of, and in that connection, a writ appeal has been filed with an application for condonation of delay.
Just make it. Shekhar Kishore Kanu filed a writ petition wherein Kamal Kishore Kanu was not made a party. Now,
Understood.
Kamal Kishore Kanu is before the division.
Understood? No, we have said,
My lord,
কি বলো?
may I clear one thing?
We'll come 2 minutes, last talking. In that connection, full stop, the third brother has filed a writ appeal with an application for condonation of delay. Full stop. Para. Sri Sen, the learned counsel, has however submitted that the brother who had instituted the earlier writ petition is no longer there. Correct?
My lord, Shekhar Kishore name.
That
I
is
can-
secondly filed.
Yes,
No longer, he
first
is-
writ petition. my lord.
first writ petition
Yes,
is no
correct.
longer there. Para. Be that as it may, comma, in the interest of justice and to conflict any And to avoid any conflict of decision, let let this matter be adjourned by a month, on which date the up-to-date status regarding the writ appeal be informed. Full stop. List on, we give a date.
My lord, actually what has happened, my lord? May I clear the thing?
Have you made your brother a party here?
This,
Third brother?
no, my lord.
That will be
Because
difficult.
our grievance is against the, my lord, the Ministry of Home Affairs, my lord.
Now, if the
And-
Ministry of Home Affairs is directed to have your name,
My lord.
what would the interest of your other brother? He may be interested.
The other brother, that is what I was submitting, my lord. The other brother, my lord, his name has been struck off from the license on the ground of security clearance. My lord, his.
Have you stated all those? in this petition?
Yes, I have filed additional affidavit.
Where? Let us see.
In additional affidavits, I have
Page?
annexed the order, my lord, passed by
You come with the instructions.
my lord.
We have a date.
I'll satisfy.
List
yes.
on the 4th, no? List on 7th of September, Monday.
Because his security clearance was denied, my lord. That's why he filed the writ petition against that writ appeal.
No, I think you need to implead also the other brothers. Otherwise, the projection which you have made is not so straight. It's not a straight projection. There are many things involved.
It's
Is
there,
it?
my lord. Yes, it's there. WPC filed by my other brother, my lord, Kamal
Okay.
Ishwar Kani. It is here. That's why, my lord.
So you're
it's not-
taking revenge. You're taking revenge.
I am not.
In a writ petition, I'll not make you a party.
No, that is not the case, my lord. Because our
coming separately.
Why don't you sit and talk and file either jointly or and authorize one of your brothers?
That is what.
In your fight, you lose your license.
In fact, now Lordship, nobody is going to get the license.
That we know.
no, my lord.
Non-manufacturing license in 2026.
Law says that. my
Under
lord,
what law?
Law says that, my lord, unless there is any adverse report, my lord, from the
Gun manufacturing is very difficult.
from the point of, my lord, security clearance, then, my lord, there is no bar. As per the arms rules, my lord, 1962. I'll satisfy all this, my lord, at the
Will you
time
be
of-
satisfied if it is a toy gun? We can direct. That will be okay.
The fact remains, my lord.
You confined to
my
toy
father was-
guns,
my
nothing
fact-
more than that.
My lord, fact remains that my father was holding a, my lord.
Those
gun
were different days, Mr. Sen.
My lord.
Those were different days. Now things have changed. Yes, next.
I am obliged.
106.
Yes, madam.
May I please, your lordship, this matter was fixed today for filing of affidavit by the
Okay, notice has been issued. Yes, madam. Collator.
The original amount claimed was 37,17,200 and something. And out of which, my lords, 20,31,870 was admitted.
Yes.
This has been paid.
Okay.
Now they are here before your lordship saying that an amount of another additional amount of 16,84,000 is admitted. That is
Yes.
what they say. But although, my lords, it's ever that this has been admitted, nothing shows, nothing is on record that it has actually been admitted. This
Have
additional
you,
amount.
what are your materials to show that these are admitted, the remaining amount?
Lordship.
The remaining amount of 16 lakhs odd, where are the materials to come to a conclusion that these are admitted?
Lordship, the earlier learned counsel has been appointed as a PP, so she has instructed me to see.
Now you have to come prepared, madam. Where are the materials? If you need some time, we can grant you some time. Unless there are materials to come to a conclusion that those are admitted in the manner required by the full bench, we may not entertain this writ petition. You might have to go to a civil court. You come prepared, okay?
This amount is disputed.
Okay, Friday. Let her come prepared. Friday. Oh, okay. What is your name?
P Das.
Huh?
Payal Das.
Heard, miss. Where is your name? Has your name come in the Wakalatnama? Have you filed Wakalatnama?
So,
You filed your wakalatnama.
Today we will file.
Okay. Ms. P. Das, Learned Counsel, has informed that the earlier counsel is not able to appear because of a new assignment, and she would file the wakalatnama shortly. Full stop. On the other hand, Ms. Kolita, the Learned Standing Counsel, PHE, has submitted that there are no materials on record to show that the amount of rupees 16,85,462 is admitted. Full stop. She has also informed that out of the total claim, an amount of rupees 20,31,817 has already been released to the petitioner. Para. In view of the above, time is granted to the Learned Counsel to file the wakalatnama and also to take appropriate instructions. Para. List on Monday next. Not Friday, we'll have more time. We'll have it on 10th.
Item 7.
Kolita.
My lord, during pendency of the writ petition, the bill amount pertaining to contract work of the petitioner already has been released. Now, my lord, my further prayer is, my lord, that is regarding interest, my lord, that I have claimed in my prayer portion of my writ petition.
Interest, you have to go to the civil court. We cannot determine interest. Was there any clause in the contract that the amount would bear interest?
Since the payment was the bill was paid late.
No, you may be entitled to claim interest, but not in a writ court. You are paying 18%. What basis? You go to a civil court. The principal has been paid.
Already paid.
Okay. We'll close this. Okay. You'll give your liberty.
My lord.
Heard Sri M.A. Islam, Learned Counsel for the petitioner. What is your name?
I'm for respondent number 2, my lords. T. Das, Standing Counsel of Assam Legislative Assembly, my lords.
T. Das.
Yes, my lord.
And who is for? Okay. And Mr. Bhuya for? Who's 3 and 4? PWD. And state is a party. State, I think you are there.
Number 1, my lords.
Doesn't matter. We'll record his name. Okay. Also heard Sri T. Das.
Yes, my lords.
Learned Counsel for respondent numbers 1 and 2, and Sri M. Bhuya, Learned Counsel representing the Public Works Department. Para?
My lords, I'm sorry, my lords, but respondent number 1, perhaps I cannot appear for
Who is
respondent
one?
number 1. This Legislative Department, my lords, State Department.
Okay, then you accept on behalf of one. Who is student principal secretary legislative department?
I'm for 2, my lords.
Principal secretary.
Yes, my lords.
You can take, but nonetheless, okay, let's make it clear. Also heard Sri R. Talukdar for respondent number 1, Sri T. Das for respondent number 2, and Sri M. Bhuya, Learned Counsel representing the Public Works Department within bracket respondent numbers 3 and 4. 3 and 4. Para? The instant writ petition has been filed with the following relief. Full stop. It is contended that the petitioner is a class 1 within bracket C contractor and had carried out 2 contracts for which the bills were unpaid. Full stop. Sri Islam, the Learned Counsel, Sri Islam, the Learned Counsel for the petitioner has, however, fairly submitted that the bill amount has been released after filing of the writ petition. Full stop. He, however, contends that there is a prayer for grant of interest at the rate of 18%. Full stop. Para. The Learned Counsel for the respondents have, however, raised an objection that the contract in question, that the petitioner has not been able to point out any clause in the contract which would entitle him to interest. Full stop. They have also submitted that a writ court would not be the proper forum for such dispute. Para. Considering the above, comma, this court is of the opinion that the principal amount, PL, amount being already released to the petitioner, comma, there may not be any requirement for further adjudication, full stop. Para. So far as the claim for interest is concerned, comma, this court is of the view that such claim which would involve questions of fact are required to be raised before the appropriate forum. Full stop. Para. Writ petition accordingly stands closed with the liberty as mentioned above. Yes. Yes, Mr. Bora.
Lordship, this case relates to non-payment of supply bills of seeds under a scheme.
Yes, notice was issued. Any response?
Lordship, the tender was floated by Assam Seed Corporation.
Clarify it, Lordship, then.
Who is for Assam Seed Corporation? You are for Assam Seed? You are for agriculture. Notice issued, Mr. Bora?
Yeah, notice issued.
Served or not?
Served, Lordship, they were.
Who appears for Assam Seed?
Assam Seed, a summary.
Names shown or not? RM Borua. Who the, which respondent?
Yes, Lordship, respondent number four.
For who is AM Sharma? AM Sharma name shown or not? Assam Seed Corporation is shown. But
Sure.
AM Sharma. Who is AM Sharma? You please try to
Yes.
locate him. We'll have this on Friday.
Yes, Lordship.
Okay. Notice was issued on 6/6/2025. And though the returnable, though the matter was made, though the notice was made returnable by 4 weeks, comma, it has been listed after more than a year. Full stop. Para. Be that as it may, comma, Miss G. Bora. That, G. Bora, we have said.
Sorry.
No, this is G. Ms. G. Bora, learned counsel for the Standing Council Agriculture Department has submitted that the concerned respondent is the Assam Seeds Corporation. Full stop. Since the learned counsel for the Assam State Seeds Corporation is not present when the matter is called upon, comma, in the interest of justice, the matter is adjourned to be listed on Friday. Please try to inform. Mr. A.M. Sharma's name is there.
Yes, Lordship.
We are not being able to locate.
Lordship, in other matters, there are similar 10 other matters as summary.
You can,
I will ask him.
maybe A.M. Sharma with Mr. Samaria, I will
Yeah.
not know.
Deeply.
Other matters, what is the stage?
Other matters relating to the same department.
What is
same
the
scheme,
stage?
They are all disposed.
Disposed of?
Many of them are disposed of. It's under the same scheme but different tenure.
Okay. You please inform Mr. Chamaria if
Yeah.
it's.
I'm appearing on behalf.
Okay, what is your instruction?
We are waiting for the instruction, Lordship. Please give us some time, Lordship.
Okay, then it will eligible, huh? This is the contesting respondent at this stage. Your name?
Jamal, Lord.
Sri M.M. Jaman, learned counsel representing the Assam Seeds Corporation, prays for some time to obtain necessary instructions, para. But this pending for a year. You better do it soon.
Lordship, we'll
List on today's 4th we'll have it on 24th. Okay,
Yes.
Lordship.
you bring the instructions.
Otherwise, documents are very clear in this.
Let him have the instructions.
For some more time to these
Hmm?
instructions also.
Notice was issued. Instructions received. What is the matter, Mr. Sharma?
My lord, the petitioners here in their landowners and on their land, my lord, they are running their shop. But my lord, the Ground Panchayat is collecting revenue from their private shop, my lord.
Okay, there is an interim order.
I am on interim, my lord.
Heard Sri T.R. Sharma, learned counsel for the petitioner, full stop para. In this case, notice was issued on 1/9/2025, and though the same was made returnable by 4 weeks, comma, it has been listed after more than a year, para. Be that as it may, comma, Miss P. Thapa, learned counsel, appearing on instruction of Sri S. Datta, standing counsel PNRD, prays for and is granted 4 weeks time to obtain instructions / file affidavit opposition, para. List on, we'll have it on 3rd of September.
Yes, my lord. My lord,
Or
may-
3rd will be, no, 2nd of September.
Yes, my lord. No, may I pray?
Interim order passed earlier,
Yes,
stands extended till the next date of listing.
further, my lord. This may be tagged with WPC number 3982, similar matter.
Similar. List along with WPC 3982 of
2025.
25.
Deeply obliged.
Urgent 13.
My lord, my security amount, my lord, I have completed the work within the time, my lord. Thereafter, my lord, I have submit a proposal.
Health
for the-
Department, yes, madam?
Yes, my lord.
Instructions?
Two affidavit has been filed, my lord, and they also, my lord, said that the legal opinion is required.
Can it be taken up for disposal?
Yes,
Yes, Lord.
because, my lord, Lakshmi, kindly see, my lord.
You don't have a good case. You are hesitating to do the case.
No, my lord.
You should be very happy.
I-
You're having a
yes, my lord.
disposal.
Point is,
Yes.
whether the filing.
Well, let him place the facts.
Lakshmi, kindly see.
What are the facts?
I have, my lord, there is a work, my lord, for the 1,46,80,147 under
What work?
contract work, my lord.
Contract allotted to you.
Yes, my lord. Under, my lord, GMCH, Gauhati Medical College, my lord. And accordingly, my lord, I have completed the work on, my lord, 16/9/2021.
Completed. Thereafter,
Thereafter, my lord, there is a, my lord, clause on the contract, my lord.
clause.
Yes, my lord, for liability period, my lord.
Oh.
That liability period is, my lord, 1 year. And 1 year, at the time of, my lord, contract, I have deposited security amount of rupees 7,34,007 rupees.
7,34,000.
7 rupees.
007. Security.
Security amount, my lord.
Deposited
Deposited, my lord.
by you.
Yes, my lord.
Yes, thereafter.
Thereafter, Lordship kindly see page 44, there is a report. I have completed the work within time and the work is satisfactory.
Then
I submitted proposal for my lord, for disposal of my security amount. But in the meantime, my lord, in the year, Lordship may kindly see annexure 9, page 48. My lord,
you
there-
had submitted a proposal for refund of the security.
Yes, my lord. And accordingly, my lord, executive engineer also, my lord, send it to the department, my lord.
Yes.
My lord, while this process is going on, my lord, Lordship, page 47, they have prepared a committee, my lord. Under, my lord, it is Department of Dermatology, my lord, the committee consists of, my lord, 3 members, my lord.
3 members.
Yes, my lord.
What
And-
happened thereafter?
And decided to, my lord, deduct rupees 5 lakh. Because in the meantime, they have, my lord, scrutinized and found that there is a damage of rupees, my lord, 5 lakh. So accordingly, my lord, this proposal was for deduction of rupees 5 lakh.
Out of 7,34,000 so and so, 5 lakhs will be deducted.
Deducted.
Okay. On the recommendation of the committee.
Committee, my lord.
Okay, thereafter.
Thereafter, my lord, I approached this honorable court because that is, my lord, illegal, my lord.
Yes, madam.
Because, sir, liability-
What are your grounds?
Because liability period is 1 year, my lord. Within that period, my lord, I have completed and also submitted satisfactory report, my lord.
Liability period is over.
Oh, yes, my lord, 1 year.
And within the liability period, there was no damage.
No damage, sir.
So the basis of this deduction is
in the
erroneous.
2024, they have, my lord, prepared committee and submitted a report. And I have completed 2021. Thereafter, 22, 23 is over, my lord.
Yes, madam. It appears that the liability period was over. Then thereafter, how could the committee recommend deduction? And if the committee has also recommended, why did you deduct?
Whether it can be deducted or not.
But can it be deducted after the liability period?
This lordship to decide.
No, we are not to decide. You have to decide. See, why do you have a liability period? Liability period cannot be for indefinite time. It is for 1 year. That means for a period of 1 year, he is under a foundation that if something goes wrong, I will be liable, and therefore I put a security of 7,34,000 with you, for which you can make good the damage or you can forfeit or whatever.
I think there is no notice also. It's have to.
But once the liability period is over 1 year, that was up to you how long you put the liability period. In matters we have seen 5 years, they also put, here case 1 year. So if 1 year it's over, then you have to refund this amount without any deduction. But considering the nervousness of Mr. Gyasuddin, we thought he had a very bad case.
No, my lord. I have a good case, my lord.
He was very nervous. And madam was very confident.
My lord. Because
These are new strategies to do a case.
because they have filed affidavit, my lord. In affidavit, they are saying, my lord, legal opinion is required. And my learned, my lord friend.
Okay, so you have filed affidavit when, madam? And reply filed, Mr. Gyasuddin? Reply filed?
No, my lord, I have not filed.
What is it? There are two affidavits. One is by R10, Director of
Main affidavit is the respondent number 1 filed by respondent number 1. It is in para page number 76.
26, 3, 25. And the other one by R1. R1, who is R1? R10 is the Director of Medical Education.
The government, my lord. Because final approval is, government is required to give final approval.
That is all? The other amount has been refunded?
Already, my lord, no, this security amount has been not paid.
They
are 5 out of 7 lakh, they stated 5 lakh, my lord.
Any amount refunded? No amount.
no.
So you are only agreed by the recommendation to deduct. Okay. The approach of this petitioner, to this court invoking the rejurisdiction is against a recommendation for deduction of an amount of rupees 5 lakhs from the security deposit made by him pursuant to a tender which was allotted to him. Full stop. It is submitted that, as per the facts projected, the petitioner was awarded a work wide order dated 27/7/2021 for an amount of rupees 1 crore 46 lakhs 80,000 147 for construction in the GMCH, correct?
Yes, my lord.
Full stop. In connection with the said contract, the petitioner had deposited an amount of rupees 7,34,007 as security. Full stop. The work was completed within the stipulated period of auspicious period, that is, i.e., 16/9/2021, and the bill was also received. Full stop. However, the security amount was not refunded, and accordingly, the petitioner has submitted representation. Full stop. It is the specific case that the period in question of the liability was 1 year. Full stop. However, after expiry of about 3 years of the construction, the respondent number 10 had formed a monitoring committee for verification of the work, and accordingly, a verification report was made recommending deduction of rupees 5 lakh from the security amount. Full stop. Para. I have heard Sri G. Uddin, learned counsel for the petitioner. I have also heard Ms. D. Bora, learned standing counsel, health department, who has informed that affidavit in opposition have been filed both by the respondent number 10 and respondent number 1. Full stop. Para. Sri Uddin, the learned counsel, has submitted that there is no dispute to the fact regarding completion of the work within the stipulated period, and which is also fortified by the release of the contractual amount. Full stop. He has also submitted that the security deposited was for a liability period of 1 year, which had expired long back, and instead of refunding the security, beyond the period of 1 year, a committee was prepared which has made the impugned recommendation of deducting 5 lakhs and deducting an amount of rupees 5 lakhs from the security amount. Full stop. He has submitted that the entire action of instituting a committee to look into the matter in the year 2024, which is after a period of about 3 years from the completion, which was made on 16/9/2021, was wholly unauthorized and without jurisdiction, and therefore the impugned action is liable to be interfered with. Para. Ms. Bora, the learned standing counsel, by referring to the affidavit in opposition filed by the respondent number 1 on 24/6/2026, has, however, submitted that all actions taken were bona fide and in the public interest. She has submitted that certain defects were noted by the committee, which had accordingly made the recommendation. Full stop. Para. The rival submissions. From the facts and circumstances, it is not in dispute that the work which was allotted to the petitioner was completed on 16/9/2021, and the bill amount in full was released to him. Full stop. The contract in question required the petitioner to make a deposit for the liability period of 1 year, which had expired sometime in the end of 2022, whereafter the petitioner had, whereafter a right had accrued to the petitioner for refund of the security amount. Full stop. The respondents were also under a bounden duty to make such refund. Full stop. On the other hand, after a period of about 3 years, a committee was prepared to look into the construction, which had accordingly recommended deduction of an amount of ₹5 lakhs. Full stop. In the considered opinion of this court, after expiry of the liability period, the authorities would have no jurisdiction to invoke the liability clause, as such clause has to be invoked during the period which was agreed upon between the parties. Full stop. This court is of the opinion that the action of constituting the committee and the recommendation for deduction are without jurisdiction and non-est in law. Full stop. The para in the conspectus aforesaid, the writ petition stands allowed by directing the respondents to immediately immediately release the security deposit of ₹7,34,007. Full stop. And to immediately release, which should not be immediately released. Full stop. And release, which should be within a period of 2 weeks, of 3 weeks from today. Full stop. Writ petition stands disposed of.
All right.
They are appearing for PWD.
M. Bhuya, Public Works Department. Okay.
16. I think 16.
16, yes.
Respondent to
Mr. S. Chakraborty. Who is S. Chakraborty?
Mr. S. Bothakur will attend this case is on the legs report 10.
S. Chakraborty, Shantanu Chakraborty. Who?
No, but a respondent.
No, that we have understood. For the petitioner. Shantanu Chakraborty or who? Or Suman Chakraborty? Suman Chakraborty. Where is he, Mr. Chakraborty? Okay, none appears for the petitioner on call. Which is probably due to the heavy waterlogging which the city has faced this morning. Para. Be that as it may, Sri, a request for adjournment has been made on behalf of Sri S. Bothakur, Learned Senior Counsel, for the adjournment for the respond number 2. Para. In view of the above, matter is adjourned to be listed on Friday. Okay.
Item 17.
What is this matter?
That debarment matter, my lord, without things proposed, without hearing, my lord.
Yes, madam, your senior Chaudhary.
Yes.
If he comes, we can take care. Otherwise, second half this court will not sit. There is some bereavement in the family. We have to leave.
My lord.
Mr. Roy, which matter? Rest matters will not be able. If this matter, Mr. Chaudhary comes, we can take it up. I think this does not involve any.
No, my lord.
Facts are very clear.
May I place the facts, my lord?
No, if he doesn't come, we have 5 minutes.
That's correct, my lord.
Can we have tomorrow or day after?
Thursday.
Day after,
Yeah.
madam, day after. Ask him to come. Yes, Transport Department, where are you here?
The matter for final disposal.
My lord, again, but at least it will come.
Today we will not be able to do it.
No, my lord,
It will come in the bottom, my lord, after I.
No, he'll be there next, day after tomorrow, we'll be there. Today we have some difficulty, we have to rise. Okay. Sahibullah matter, huh? Heard Sri G. N. Sahel, Learned Senior Counsel for the petitioner. Also, however, some accommodation has been sought for on behalf of Sri S. P. Chaudhary, Learned Counsel for the NIT. Para? As urgency has been expressed, list on 6th. Your J. Bora, na? However, Miss Embora, the name, naam to likhe diba. Okay.
Interim order, yeah, my lord.
Interim order passed earlier. Stands extended till the next date of listing. Okay. And madam, transport when? Urgency is there. No urgency. Other side, ma'am.
Senior counsel was appearing.
Mr. Chalia, when can we have this?
Next
Friday?
week.
Friday? Okay. Paucity, huh? Friday. Okay, Martin.
But tomorrow also is lost. But this is lost, man, this is matter.
Okay, Friday, let it be on Friday. Mr. Gupta, which matter?
This matter, record was called for, we have been to report.
Other side.
Others is not.
We have a date of your convenience. Thursday we can have further hearing. Okay, this matter we will have this matter.
Friday.
That Dhing matter.
Thing made.
Thursday. This is for further hearing. We'll have it as the first item. Okay. Mr. Roy was there. Other side, J. Roy. Okay. This matter was heard in part on slate to deliver. However, due to paucity of time, it could not be taken up today. Full stop. List for consideration on Thursday.
Lordship, item number 29, can it be on day after tomorrow?
Urgency is there or what?
No,
Then we have some date. If we have slot, we'll have it on day after tomorrow also. No problem.